but it is a privilege to have her here. There are many other credentials that I could list. I just wanted to mention to you all the context of this conversation. This is a prelude for the Northern District. This is a prelude to the Northern District of Texas Bench Bar Conference, which is going to be on April 14th. Many of you will be there. We're excited to have you. We are nearing a sold-out crowd, and so we hope that you can register if you can come. We wanted to have an event like this as a prelude to that because we think it is a very timely topic, similar to the topics that we will be covering at the conference. And I think our general mentality is that if we are to help navigate civil discourse and help cultivate it, there's no better place to do so than in the context of law schools. And as attorneys, we are at the forefront and we are setting the example for the methods in which that discourse will occur. And the panelists that we have here are all exemplars of that mission, and Judge Rutherford is going to focus on bringing that out today. So with that, I will hand it over to Judge Rutherford. At the end, towards the end, we will give you the COE code so that you can all get the hour of ethics credit. And if you have any questions that you'd like to pose to Judge Rutherford, you can email them to me. You got an email from me when I sent you the link, and I will filter those through to Judge Rutherford. Thank you all again. Judge Rutherford, I'll hand it off to you.
All right. Thank you, Grant. It is my privilege to be here today, and I want to say good afternoon and happy Friday, and thanks to everyone in the audience for joining us, and especially thank you, Deans, for participating today. I want to dive right into the substance of our conversation, but I would be remiss if I didn't take just a moment to introduce, or at least identify, our panelists. We have Jason Nance, who is the Judge James Noel Dean and Professor of Law at SMU Dedman School of Law. We have Brad Tobin, Dean, and MC and Maddie Kasten, Professor of Law at Baylor University. We have Jack Nallen, Dean, and W. Frank Newton, Professor at Law at Texas Tech University. We have Felicia Epps, Dean and Professor of Law at UNT Dallas College of Law, and Bobby Adier, Dean, and Anthony G. Busby Endowed Dean's Chair, Vice President for Professional Schools and Programs at Texas A&M University. So this is a very distinguished panel, and we have a very timely topic, I think. Dean Adier, I made a note of your statement on your page on the law school's website that law offers a shared framework for civil discourse and engagement. It's among the most crucial ties that bind us together as a society. And as a law school, our vital mission is to educate the designers, builders, and advocates of that framework. I'd like to use your idea of law as a framework for civil discourse and engagement as a springboard for our conversation today. Can you elaborate on that statement, and what is civil discourse?
Awesome. Well, thank you, and it's a great pleasure to be with all of you, Judge, my fellow deans, and to talk about what I think is really one of the most important topics that we should be discussing as a nation and clearly as lawyers and the legal community. So when I think about the framework idea, the core notion is that we are a law-based society. I mean that in the fundamental sense of our constitutional order and rule of law emphasis, but frankly, I also mean it in the sense of what are the TV shows people watch and the movies they're excited about. We really are a society that thinks of law as a central ingredient of who we are and how we engage one another and how we talk to one another. In some ways, that invites the possibility that if we agree, and this may be some of our conversation today, if we agree that we're at a moment when civil discourse is in some peril, where there are challenges to the scope and breadth and opportunities for civil discourse, perhaps there's something for us to borrow and learn from law. As I have said to some in the past, it's not that every time there's a disagreement, everyone should sit on two sides of the room with one person sitting in a robe higher up and engage in that conversation. But there are elements of what we do in law and how we engage in dialogue and discourse and legal analogic reasoning that perhaps we can teach more broadly. We can teach in the high school level, we can teach in colleges, we can teach in our community meetings by way of conditioning people to this idea that lawyers haven't perfected, but we practice a kind of model that forces us to acknowledge that there are two sides to an issue, that each side has to have their chance to speak, that each side has to rely on the same basic facts, and so on and so forth. So that's the core notion of it. And then you ask the question, what is civil discourse? So I would say, again, it's the fundamental ability to engage in dialogue across disagreement and implicit in engaging in dialogue is that it doesn't end, right? It's an ongoing, kind of dialogic, pattern in which I say something, you say something, I say something, and it doesn't abruptly end with I hate you, or you're crazy, or I'm not talking to you anymore. But we're able to continue that, and in that way, we hopefully move towards a shared solution or a common solution. But even if we can't, at least understand the other side that much better.
Thank you. And it's interesting that you mentioned this is civil discourse is something that we might even start teaching before people get to law school. Dean Nance, you began your career in education as a middle school math teacher in Houston. Given your breadth of educational experience, what do you think civil discourse looks like?
And also, thank you, Judge Rutherford, for the opportunity to participate. And I want to thank my fellow deans here. This is going to be, I think, a wonderful conversation that we can have. And I think Dean Audier provided a very good explanation of what civil discourse means. I'll just add a few things. I think that in order to have civil discourse, and these are things that can be taught, I think, at a very early age and should be taught at a very early age, but it needs to be coming from an authentic, genuine place. I do think that people need to be open. I mean, it needs to be an open-minded conversation, which means that I think that you need to have the mindset that I can change my mind on this. If you don't have an open-minded mindset, it's not going to be a very productive conversation. I think that everyone does. This is something that Dean Audier was just talking about, but everyone needs to have an opportunity to have input and to be heard. And it doesn't mean that we're going to accept every idea that comes, that comes forth. But at the same time, everyone should have an opportunity to provide input and to be heard. And we should have some rules about some timing. We don't have interruptions, that we're giving everybody a fair chance to explain their views. And I also think that we still need to exercise a lot of emotional intelligence, and we can talk a little bit about that later. But understanding when the argument may become too heated, and sometimes we do need to take a step back and take a break, and we need to understand our own emotions. I mean, emotional intelligence means we need to be regulating our own emotions and understanding the emotions and the response that our words can have on others. But if we're emotionally aware, sometimes we do, I think, need to take a step back and a time out and continue the conversation at a later time.
Thank you. Dean Allen, I know that when you were a Senior Associate Dean at Ole Miss, you were able to moderate a lecture series event featuring Supreme Court Justices Scalia and Kagan. What was that look like? Was that an example of civil discourse?
That was an example of civil discourse. When Antonin Scalia passed away a few years ago, there was a wonderful picture from that event that was Scalia saying something and Justice Kagan laughing in a very positive way. And they were friends. They were on opposite sides of a lot of cases. They agreed on some cases, but they were able to put aside those disagreements and respect each other as colleagues and preserve their ongoing relationship. They were actually in northern Mississippi on a hunting trip together. So they're actually friends and traveling together. And I think that epitomizes civil discourse. I would agree with my fellow deans, that mindset that we don't have to be disagreeable with someone because we disagree with them. We can keep in mind that there are differences. We can keep our own mind open. We can think about other perspectives, try to understand why other people have the thoughts that they have, and we can still maintain relationships. I think as we're doing problem solving in whatever setting, maybe in the legislature, it's really important to remember that we're also doing conflict resolution. This picks up on some of the other points. We're trying to preserve relationships for the next set of problem solving. And so that ability to resolve our conflicts in an amicable way, move forward with the best policy, and keep everybody engaged with the next decision, I think is crucial. So that was a wonderful evening, and it was a nice example for the students at the university of people who have very different opinions on very hot button issues, still managing to be friends and actually vacationing together.
That's wonderful. Dean Tobin, you have been a law school dean for more than 30 years. How do you, and I'm very curious about your observations on not only the current state of discourse, but sort of how it's evolved over the time that you've been a law school dean. What are your observations?
Well, thank you, Judge Rutherford. Obviously, if we look back over the past decades, at my age, I'm in the latter part of my 60s. I'm thinking back to the decade of the 60s, the decade of speech in regard to the anti-war movement, the civil rights movement, feminism movement, and the like. And the concept of free speech in our nation at least in our more recent history, is rooted in the protection of those who might otherwise not have a voice. We're with a group of deans today. We're all on university campuses, and I think it's important to note that as we have seen discord arise in regard to free speech rights in recent years, in a sense, things have kind of been flipped. Instead of free speech to make sure that the voiceless have a voice, we instead have seen free speech as something perhaps to be feared by some audiences because they choose not to listen, they choose not to hear opposing viewpoints. And of course, that is not a good pathway to follow in regard to broadening one's perspective. John Milton, great free speech theorist, pointed out to us that the mind is only sharpened when we are confronted with ideas with which we do not agree. And I think that free speech is taking some difficult hits compared to what we have seen in earlier decades.
And Dean Epps, you may even have a different perspective. You're dean at a law school campus in downtown Dallas, which is one of the 10 biggest cities in the country. And early in your legal career, you served 10 years in the United States Marine Corps. So you have some different perspectives on civil discourse and what the state of that is in our country today.
Well, and actually, I was thinking about my time in the Marine Corps as I was listening to everyone talking, because, of course, Marine Corps is special, being a subculture with a certain norms and the way that we behave. But one of those things, and I don't think this is uncommon, actually, is as lawyers in court, some of my best friends as defense counsel were prosecutors. And so there's the point at when we take break for lunch in court that we were going to exercise or work out together that lunch hour. And we didn't want the client to see that we're good friends, because somehow there's this expectation that there's animosity or whatever, when there really wasn't. We're colleagues. We're on different sides. We're zealous advocates. We have a disagreement, perhaps, about the outcome of a case, but that didn't mean that we were not also friends and colleagues. And I think that kind of sense is becoming lost. Just because we're on different sides of issues doesn't mean that we don't like each other. And I would also say that we have to remember, in the whole context of this, it's listening respectfully to the other person's views, listening and really seeking to understand, rather than listening to figure out what is going to be my comeback to that person. If we're listening to try and understand that point of view, you may never agree with it, but at least have a sense of what it is about and have respect for that.
Thank you. Now I'd really like to give each of you an opportunity to highlight some of the things that you're doing at your law schools to cultivate civil discourse. I'm very interested in how, as an institution, you're trying to promote that amongst people who will be leaders in this arena. Dean Audier?
Sure. So let me begin with kind of the most challenging aspect of that is, obviously, and again, as folks have seen in the news, there's been lots of coverage recently about events at law schools and programs and the dynamic of those. We've been pretty keenly focused here on how do we both encourage, invite, push as much as we can, as public institutions and as private institutions, the students to both recognize the rights and responsibilities that come with operating in a framework in which there's significant free liberties protection, but we're also a community. So I would say, again, a lot of these events and programs create opportunities for law schools. We do that as well when we use them in that way, to educate students in that regard. I don't want to suggest that it's always easy to do that. Obviously, there can be tensions between the passions of the moment and some of those demands, but we do our best to sort of use those as learning moments with the students. I will say that to me, those tensions are really reflective of our operating in society as a whole. While we are some of the dynamics at work today are a function of the fact that we can silo ourselves, so we are only talking to people who agree with us. The reality is that it's hard to do that in the work media feed may only give me people who agree with me, but in the real world, that's much harder to do. And so in some sense, I think law schools have this, this unique opportunity that we are all forced into this framework together. And so that's one of the things that I would say is these events, as much as they can be a source of tension and maybe for the deans would agree with me, headaches, sometimes for deans, also create opportunities for us to teach the students and for them to learn.
Dean Tobin, what about what you're doing at Baylor, or what Baylor's been doing?
Judge, my decanal colleagues, they know that the ABA has promulgated what's referred to as Standard 303. Essentially, 303 puts an obligation upon the schools, a good obligation, to develop students and give students the opportunity to essentially be exposed to and even immersed in the norms of the legal profession. And going back to Dean Audier's opening comments about the law as a construct in which we can resolve our differences, I think that it's important to have our students very much intentionally recognizing that the school is trying to make sure that they are exposed to different ideas. Because those are, of course, that's the norm in the legal profession, at least in the litigation perspective, and also, frankly, in the boardroom as well. Whenever we negotiate a contract or a deal or the like, I believe that at Baylor, what we have done is we have opening up at orientation a lengthy session on civil discourse and the norms of the profession. I'll note also within the context of a law school, we all have many different student organizations. For instance, here at Baylor, we have an American Constitution Society, we have a Federalist Society. I have encouraged the student organizations when they select speakers to actually do speaker events in the context of a debate. I don't think any of us learn very much when we listen to a speaker with whom we already agree. Our minds are enlarged, our perspective is challenged only when we hear the opposing viewpoint put to the edge of a sword by an advocate who can argue from the other side. As we progress along in life, I think it's almost a universal experience that we begin to see less black and white, and we begin to see more gray tones in most of the areas of living and profession. And we try to make our students aware that they must be self-aware of that type of necessary progression.
I really like that idea of self-awareness. What's happening at Texas Tech, Dean Allen?
We do a lot. We do a lot of formal messaging. We do a lot of more informal messaging. We addressed this issue at orientation. We had a wonderful panel, the Day of Civility panel for Constitution Day last September, that was exactly really about what this panel is about, which was the importance of lawyers as leaders, the importance of civility in the legal profession and in politics more generally, and helping people understand the value to their professional career and the value to society of maintaining civil discourse. We've done faculty retreats with civility components as well as wellness components, because I think those are very closely connected. A lot of incivility comes from a place of I think, unwellness, a lack of emotional control, lack of resilience. So we've done student leader retreats that address civility and wellness issues. I think most of the best things happen in the classroom. I'm sure it's true of all the deans here. I have a wonderful faculty that very strongly believe in professionalism, and they model that civil discourse in their classes every single day. And so with additional supplementary events, and then I have a wonderful dean of students that she and I and some of the other associate deans, when students have conflicts, which they inevitably do, we come in and mediate sort of gently behind the scenes, redirect people, link things to their professional career. So students are having a conflict, we link that to conflict they're likely to encounter as an attorney. It helps them get out of the student mindset into the pre-professional, I'm going to be a lawyer mindset. So we do a lot of that, just one-on-one, kind of light touch, mediation, counseling, redirection to people. I'm sure we'll talk more about the wellness issues, but I think as Jason was suggesting, that emotional intelligence and wellness is a big piece of the civility issue.
I agree. I'm very interested. Dean Nance, do you want to talk about that now?
Sure, and a lot of my comments I think are going to align with some of the things that my colleagues have said. But and this analogy I think is used quite often. But we are a big tent, and we're a big tent of universities in which all types of discussions are going to take place at all ends of the ideological spectrum. And it's important that we continue to hear all different types of viewpoints. I mean that is so important that we're actually being intentional about seeking out viewpoints that are different from our own, and we may come back to talk a little bit about that later. But some of the specific things that we're doing at SMU Law is that within our first or entry level class, we divide them up into different groups. We call it the Inns of Court, borrowed from of course the sort of the federal Inns of Court structure that has been so productive, I think, to bring lawyers together. But we divide them up for lots of different reasons. One is to build community, smaller communities among the students, because that trust is so important. And sometimes in a big law school, you can sort of lose your identity or lose sort of perspective. And so we want to make sure we're doing our best to build that community. But then, of course, offering opportunities then to discuss civil discourse and opportunities to practice that. We are introducing a new course in the fall here. It's on professional identity formation, and a key component of that will be how to civil discourse and how to model it, how to practice it, why it's important. So that's something we look forward to. And finally, I'll just echo what was said earlier about being intentional about bringing students groups together. And I think that we can do, all of us can do a better job with this, making sure that we're bringing, the Fed SOC students with the ACS students and have them plan those events and being intentional about it. And I think it's important for a couple of reasons. I think that as deans, we could create an event in which we would have people from different viewpoints, but I think it's better that we provide some guidance to the students, and then the students actually do it. And so, and you can do that through these student organizations. And so, having some planning meetings in which they're talking to one another, which they're planning this together, they're being intentional about which type of speakers they're going to bring, and planning the different types of questions. They're doing that. They're now modeling what it means to have civil discourse and planning an event in which civil discourse will be demonstrated by being intentional about hearing ideas from all sides on particular, and sometimes on particularly thorny issues.
Wow. That is really interesting. Dean Epps, what about UNT? What are you guys doing?
Well, a few things. Well, and first of all, I think I join with my colleagues in saying it's very important that the faculty and staff role model these matters, both in the classroom, how they deal with each other, and how they deal with students. And I'm very proud of how we do that here. We have a first-year program, the Bedford Mentors Program, where students are in small groups led by a practicing attorney. And so they have the opportunity to discuss a variety of issues. We're developing that into our course related to professional identity development, where there'll be a more robust discussion of these issues and several others in the process of just developing who they are as professionals and being intentional about that. And finally, our student organizations are quite active in bringing various speakers to the campus who would have different points of views and encouraging participation by the student body. I think the students, the way some of the organizations work together, role model that civility. They may have different purposes or different goals, but they can collaborate on things. So that is, those are a few of the things that we're doing.
That is wonderful as well. And I heard several of you mention emotional intelligence, fear, wellness, intentionality. I'd really like to dig a little deeper into that. And if you have any specific habits or practices that you think are helpful for students to facilitate civil discourse, or for professionals, young lawyers, experienced lawyers, how do we become more intentional, more emotionally intelligent about this very important topic? Anyone?
I'll just throw out one that, again, I think of, remember there was a book years ago that said everything I needed to know I learned in kindergarten. So the one I tell my students most commonly, and it actually totally makes sense for us as lawyers, is ask questions. Like you should have, on the low end, have 10 questions, maybe as many as 20 or 30 questions before you have a reaction and response. And there's a few reasons for that. First of all, because again, we were better lawyers and better citizens, I suspect, when we're better informed. But also, frankly, oftentimes a lot of the immediate things, the right questions in the right order, the thoughtfully constructed, will oftentimes reveal a more complex and textured landscape than black and white, and those are the only two possibilities. So that would be the one that I would sort of throw in. I'm sure others will have better ones or other ones, but ask lots of questions is the one that I would flag for, and I do flag for our students.
That's a great one.
So I'll jump in for just a second. First of all, I think that we need to make sure that the students understand why emotional intelligence is so important. So spending time on the why, and because you can be a very capable individual, but if your emotional intelligence needs work, you're going to have a hard time finding success in this world. And so I understand the importance, I think, is critical first. And then I think that there's some benchmarks, and I talked a little bit about this before, but emotional intelligence, when you break it down, a lot of it has to do with self-awareness, a lot of it has to do with self-regulation, and a lot of it has to do with empathy. And empathy is, we all know what empathy is, but I try to practice it when a student comes into me, or a professor or somebody else, and they have a critical problem. I really try to put myself in their shoes and think about, how would I feel if I were in their shoes? And that helps me, I think, become a more compassionate individual and more open-minded. Even if I disagree with what that person is saying, at least I get a sense for how I might feel and how I might respond and how I might perceive different things. And so I think that's important, but there's some also different markers here. So teaching students to be aware and to practice things like managing your emotions in difficult situations is important. At least understanding how you're feeling and being present, saying, I understand this is making me upset right now, and I need to be on alert, that I have to be on special, my special behavior, try a little bit harder so I don't let my emotions go out of control. It sounds obvious when I say that, but I think it's important for the students. And for some, it's not obvious. For some, they do need a little bit more practice and self-control as they do this, and just being sensitive to others' feelings and a genuine interest in other people. And I'll also just say self-confidence. Self-confidence is also an important component of emotional intelligence. And something that someone said to me once as I was moving to a new place in Dallas and SMU that has kind of stuck with me, which is assume that people like you. Assume that they want to be around you. And I think that's true for most people. I think people do, for most of us, I think we do genuinely like each other, and we do want to be around each other. Maybe not all the time. Maybe not everybody wants to be around me all the time. But at the same time, that has helped me sort of have a little bit more self-confidence as I'm navigating this new responsibility. And the last thing I'll say is, most of the time when you disagree with someone, when you get to know them on an individual basis, it's so much easier to just resolve a dispute. You can see them as a real person. They're struggling with you. We have a lot more in common than we have differences. And you can see you got a real person in front of you that's struggling with things that you do too. And that helps us be more compassionate and open-minded as we seek to, further the goals that we have.
I fully agree with Dean Nance. I'll add, it's called emotional intelligence for a reason. Many, not all, but many of our emotions are linked to our intellect, and it's easy to become discombobulated or upset when we hear about ideas that don't conform to what we intellectually believe to be the case. And of course, this is very important in speech fora that we recognize that connect. And in our modern day internet world, many public policy arguments take place with very little attention given by either party, often to the facts. The facts pretty much have suffered drive-by shootings time and time again in our cyber world. And I would encourage our students, if they want to feel more grounded emotionally, it's important when you're dealing with a public policy issue or any other issue that comes into your perspective or your space that you understand deeply the arguments, you understand the factual basis deeply. So important because we're living in a nation where alternative facts, or the facts that I happen to know, or the facts that I learned from a couple hits on the internet, or the facts that I'm going to ride home. Well, that's nothing but ignorance speaking to ignorance. And we can be more secure emotionally in many ways if we are confident, as Dean Nance noted, of the handle that we actually have on the facts.
Well, and don't assume that you know or understand someone. Really ask the questions and seek to really do that and to really develop a relationship. Part of what we teach them in law school is critical thinking. They're supposed to use those skills. And remember, part of that is going to be gathering the information that you need in order to make any decisions or judgments about anything, and being open-minded to others who may have a different perspective or bring something more to the table.
Dean Allen, do you want to chime in here? Oh dear.
We can't hear you, John.
Judge Rutherford, can you hear us okay?
Yes, I
I
can.
can hear you. Can you hear me?
Now I can hear you.
Okay, a little technical difficulty. I missed just a little bit of the discussion of the technical difficulty. I would say lots of things will help students. We recommend meditation, counseling, cognitive behavioral therapy, but just some of the common sense things you can do are just count to 10, take a deep breath. Remember, you're talking to a real person. One thing I suggest to students is watch your screen time, because the amount of time you spend, especially on social media, there are lots of studies indicating that's linked to wellness issues. And in particular, remember that when you're talking to people in person or in a forum like this, it's not the same thing as anonymity on the internet. And the toxic behavior we see on Twitter so often, that's there. That really shouldn't even be there, but it certainly can't be brought into a different forum. So as you're preparing to be a professional, you're going to be in an adversarial, oppositional profession. You want to act with civility. You want to act with civility as a law student. But I think those are some of the things I find most helpful for people.
And that's an interesting thing that you're doing with training lawyers. You're training them to be advocates, oftentimes in adversary positions, and it's something that lawyers we deal with, and sometimes it can be you can get really caught up in the moment and carried away. And I think you've all offered some really great ideas to get us started about asking questions and listening to the answers and having some self-awareness and connecting the intelligence, the brain to the heart and the emotion. And as we talked, I heard several of you mention the various forum that we find ourselves in on social media, on the internet, with different versions of facts, having to be careful of silos and sort of this search for truth. And what, as you approach your students in your role as leaders of your law school, sort of how does this idea of truth fit into civil discourse and talking about truth? Or should lawyers work to achieve or find truth?
Somehow that just struck at my heart, the whole issue of truth, because one of the things they try to drum into you as a Marine, let alone a lawyer, is that Marines we're truthful. And I think that's important if you're developing trust with your faculty, with your student body, that there is that kind of that integrity piece there, that they can rely on what it is that you're saying. And to me, another part of that is being sure. One of the things I value as a leader, for instance, is candor. I want people who work for me who are going to tell me the truth, but there's a way to say things. And sometimes you can put the truth in a hurtful way that's not helpful, or you can, I guess, as we've been talking, use some emotional intelligence in how to express that truth to someone else. But I think truth is something critical, but it's important that it be spoken in love for the person you're communicating with.
I would agree with that. I would say it's really important to be truthful as a lawyer, as a leader. But I think one thought here would be in civil discourse, we're partly searching for truth, but I think a better mindset to be in is that we're searching for mutual understanding, improved understanding. So the learned hand's famous quote, which I will paraphrase because I can't quote it off the top of my head, the true spirit of liberty is the spirit that's not too sure that it's right, but seeks to understand another person. And I think if we're in that mindset, I believe in truth, and I think we all should. There's factual truth. I think there's truth in the realm of values too. But the first thing in civil discourse, I think, is trying to understand why people disagree and show respect for their viewpoint.
How do you identify the facts, right? Who are the sources of expertise? Remember, all of these things are under challenge, right? The very notion of expertise is not what it was a few years back. But so, the more we can condition folks to some of the practices of how we evaluate factual predicates and come to agreement or not agreement, come to resolution on what are the facts, right? That I think is as lawyers, our contribution is partially the principle that truth matters. Great, but other religious leaders can do that probably better than us lawyers. But what we can offer is this notion, this framework of there's a process by which you have your conception of the facts and I have my conception, but ultimately we are aligned on some common set of facts, and that becomes then the basis for decision.
Yeah, and I'll just jump in as well. I think it's something that somebody said to me once, which is we're free to debate arguments and ideas. We're not free to debate the facts, and I think that's very important. But at the same time, I think we do have to recognize that that we don't have a complete understanding of what facts are. And I've been trained. I think that we can do a better job, I think, in the legal profession of training people to be comfortable with statistics, with empirical studies to kind of dig into, because that's a way in which we sort of come closer to the truth. I'm a big believer in data. I'm a big believer in numbers, but at the same time, I understand, with some of the training that I've received, that you can manipulate in many ways. And in some ways, you can just become more comfortable. I believe that there are certain, but I think it's when you're gathering statistics, when you're gathering data, you can become more comfortable. It's pretty rare in which you're going to have 100% certainty. So also helping people understand that you do need to be open-minded and understand the weaknesses that the truth that you might have presents itself. And the last thing I'll say is that just another important principle, which is it is less important about who's right, and it's more important about what's right. And I think that many times we do get caught up. It becomes personal about who's right, and we keep score, and you were wrong here, and I was right here. And I just don't think that's very productive. And at the end of the day, if we all exercise some humility and we try to understand each other and move closer to truth, it's about a process by which we're trying to figure out together what's right, not who's right. And that can be a very messy process sometimes. So we have to be comfortable being uncomfortable sometimes. And that's something else I think we do need to teach our students, is that this process, coming to truth and the adversarial process and being, sort of engaging in civil discourse and dealing with thorny issues can be very uncomfortable for people. And as lawyers, we have to be, as educators of future lawyers, we have to prepare them to be comfortable in that process, because that is the only way in which I think we're going to make true progress as we listen and wrestle through these very difficult issues that our nation is facing.
I think Dean Nance is spot on in the context of law schools. When we consider our Seventh Amendment and Sixth Amendment jury rights, I have found that new students, 1Ls in particular, when they begin to read the cases, they ask the question, well, what are the facts anyway? And that leads to a wonderful opportunity to talk about the jury and about the imperfection we have within the legal system of discerning what the facts are. But as it's often been observed, it's the best that there is, even with its imperfections.
I agree. And we have about 10 minutes left. So I want to make sure that everyone gets an opportunity to sort of put some sprinkles on the sundae and give us some final thoughts. As we sort of close this too short conversation about civil discourse, what is it that you'd like to leave the audience with?
Wow. I think I'd like to leave them with what Dean Nance said, I love that. I wrote it down. Assume that people like you and want to be around you. Let's start from that basis and enter conversations. And if I assume that you like me and want to be around me, even if you don't agree with me, we can still work through that and work towards relationships and resolutions of issues.
That's a very hopeful place to start. I agree. Dean Allen, what about you?
I would say the phrase hurt people, right? It's so important to understanding civility that so often what I've seen in my career is that the instances of incivility come from a place of unwellness, and that person needs redirection and they need resources. And I'll say also hurt people are more sensitive to instances of incivility. So it suggests to me the close tie between academic freedom, free speech, civil discourse, and wellness. And I know all the law schools in Texas are working on wellness things, but teaching that emotional intelligence that we've already talked about to our students as part of professionalism, I think is really important, and providing resources to students. I will say, you know, the cliche as older people, I was a kid in the 70s and a teenager in the 80s, is that kids today have it easy, but I think the younger generation has it harder than we had it in many ways. And I think some of the instances of incivility we've seen do come from places of unmet needs of that generation. So I think having that compassion and grace for our students and working to help them deal with the problems their generation faces is very different than, I'm Gen X, very different than my problems. I think that's the place to be as educators.
And I think that is also hopeful for the future of the profession. As lawyers, we often struggle with mental illness, with substance abuse, depression, anxiety. And so if we're focusing at a very early point in a professional career on wellness, taking care of ourselves, taking care of each other, I think that that's a very hopeful outlook for the profession. Dean Tobin?
I think that the word humility would go a long ways in terms of putting some oil on the troubled waters of our civil discourse and our public discourse in this nation. Humility, mindful humility, can be a powerful antidote to incivility. And also, there's that wonderful adage about when you're dealing with matters of disagreement, seek first to understand before being understood. And of course, that leads to the matter, it's already been mentioned, of listening. Let's face it, so many of us, we don't listen. Instead, we're formulating our response to whatever idea or query is being posed. And a little bit of humility, a little bit of willingness to just understand, and a little bit of willingness to actually listen carefully and try to integrate the ideas that are being expressed, I think can be powerful antidotes to the ills that we now face in civil discourse.
Dean Audier?
So again, in the hopeful vein, and I oftentimes tell folks that we are at a moment, you know, like all things, pendulum swings one way or the other. We are, I think, at a moment of significant incivility in terms of the way we engage one another and incapacity to engage in civil discourse. It's important to know that it's not the first time, and it won't be the last time. However, we work our way out of it. The reference I oftentimes give is that if you look at the public and private communications between John Adams and Thomas Jefferson, they had a quality of incivility that would probably make most of us blush. And yet they found a way, after each of them had left office, to engage in not just a civil discourse, a constructed discourse, and actually an affirmatively warm discourse. I mean, I think it's fair to say they grew to be friends, notwithstanding that history. So I think it is possible for us to work our way through this. I think, to a word that was used earlier in different contexts, it has to be intentional. So we have to, in some sense, evaluate for us as each of us as individuals, for our institutions, and for our communities. Is this the way is this the way we want to live? And if it is, so be it. That's our choice. But if it's not, there are paths, but we have to be intentional about the kind of patterns of behavior that I think we've been talking about today. And I do think that law schools can play an important role in that, given the centrality and importance of lawyers to the construction of our social order. To come back to the first thing I said, we are a law-bound and law-oriented and law-focused society. at every level, from top to bottom. And so if lawyers, as a matter of their conditioning, think of certain patterns of engagement, not just as what they do in the office, but what they do in their communities and their churches and in their organizations that they're a part of, I think that really has the potential to significantly shift the direction that we are on right now.
Dean Nance.
Yeah, I appreciate what Dean Nadia just brought up about John Adams. I'm reading a biography right now, John Adams by David McCullough, and it really is a stirring, just an example of someone like John Adams who exercised these principles. And not just with Thomas Jefferson, but also with John Dickinson. I mean, there was a vigorous debate in Philadelphia that took place regarding whether or not they were going to leave the nation or stay with England, and both of them felt very passionate about their ideas, but they had opportunities to voice those things, and they listened carefully. But it doesn't mean they didn't shy away. I mean, they continued to stay at this, and they were acting with a high regard with one another, and the right outcome, I think, was achieved. I'm reminded by a saying that's people care. They're not going to care about what you say until they know that you care about them. And I think that's an important parting thought, to be intentional about making sure that you have, that you're trying to have their best interest in mind. And if there is a disagreement with words, I think it's a good practice for all of us to find ways in which we can actually come back later and maybe manifest or have a greater manifestation of respect for that person after you've had a difficult conversation. So they don't perceive you to be an opposing enemy, but you're on the same side, even if you do disagree about that. And we can assume that, but I think it's also good to be intentional about that. And I'll just two more quick, very brief thoughts. When I was at Ohio State, and I was preparing to teach, and this was when I was teaching some statistical classes at the graduate level, I went through some kind of a teacher training, and one of the other professors said something I thought that was very insightful. He said that people sometimes, when they're confronted with ideas that are different from them, and these are ideas that they've held closely for a long time, they need a period to what he called to grieve, a grieving period of those ideas. And because you rarely can change somebody's mind. And we've talked a little bit about this, but you rarely can change somebody's mind overnight or in the moment. That is a very rare occasion. And I think that sometimes when we expect that, sometimes the emotions get a little bit heightened. But if you put your points, I think, in a respectful manner, and then give people time to process and to think, and good people want good solutions, but sometimes it takes a little bit of time to get there. So giving people time to grieve or to consider these ideas, I think is essential. And then the last point, we've talked about this at length, but being very intentional about seeking out the ideas of others. There was an editorial that I read this morning in the New York Times about, from Pamela Paul. It's called "Students Who Shut Down Speech Must Have the Most to Lose." She was talking about her relationship that she used to have with Bret Stephens, who was a very conservative individual. She happened to have different thoughts, and she said that she missed that debate. I mean, that debate is, as said before, of sharpening your own ideas, thinking about things from a different perspective. I really do think that's the only way to grow. We have to get outside of our comfort zones and, again, get comfortable with the idea of being uncomfortable, but we have to be intentional about it.
Well, I am, for one, am very encouraged by this experience with you and hearing about what Texas law schools are doing. I think it is hopeful for our students. I think it's hopeful for lawyers. I think it's hopeful for our country that we can learn, and that lawyers can be an example of how to engage in civil discourse, and that with time and practice, we will get to the place where we want to be, that it is not as dire a situation, perhaps, as the pundits say. And if we step out of those silos, maybe we can be encouraged, or at least recognize that we have some work to do and take some specific steps to get to a place where our discourse is more civil and it is more productive. So I want to thank you all very much for joining us. I think Grant has the CLE number for all of our participants. And while you make a note of that CLE number, I have a brief ethics-related public service announcement that I need to give, which is that Section 6 of the preamble to the Texas Rules of Professional Conduct states that every lawyer, regardless of professional prominence or workload, should render public interest legal service. In the words of Associate Justice Sotomayor, we educated, privileged lawyers have a professional and moral duty to represent the underrepresented in our society, to ensure that justice exists for all, both legal and economic justice. In addition to fulfilling a professional obligation and helping the community at large, a lawyer's involvement in pro bono work can be extremely rewarding. Attorneys who practice in the Northern District of Texas have a rich tradition of providing pro bono services, including service as appointed counsel in criminal cases. Your assistance with representation through established programs is invaluable, and the court appreciates your service very much. While there are many rewarding ways to discharge your responsibility to render public interest legal service, I want to talk to you briefly about the needs of victims of domestic violence. In September 2018, Congress passed the POWER Act. POWER is an acronym for Pro Bono Work to Empower and Represent. This act acknowledges the pervasive problem of domestic violence in this country and requires each United States District Court to annually promote pro bono service to assist survivors of domestic violence, sexual assault, and stalking, and to engage citizens in assisting these survivors. In response to the POWER Act, I encourage you to join your many colleagues who have already assisted with domestic violence cases in Texas. Please learn more about how you can help in your community and take action. One place to start is by looking at the many pro bono opportunities found on the texaslawhelp.org website. Please review those opportunities that are available and offer your services, particularly to victims of domestic violence. And with that, I want to thank all of the panelists. Again, your insight here today was really enlightening, and I want to wish everyone a wonderful and safe weekend. Thank you.
Thank you, Judge.
Really, Deans, wonderful. Thank you. Thank you.
Thank you, Judge.
Great to see everyone.